What is probate? Hi, I'm attorney Paul Bernstein of the Bernstein Law Group. We frequently get asked that question. I think to illustrate the issue and when probate court would be involved after someone dies, let's talk about this example. Let's say Jill has a bank account just in her name. Jill passes away. The bank will freeze that account. It won't go to her only son until the bank has legal authority to give it to the son, because the bank doesn't know who the next rightful owner of that account is. It's not by default the son. So that's where the probate court process steps in. Probate is the legal process for distributing your property that you own just in your name after you die. Doesn't matter if you have a will or not. It's all about ownership. So it's all about dealing with assets, property, financial, real property, what have you, in your name alone when you die. And the court is the one who will determine who will have control of that property after your death and who gets it as an inheritance. Now, if you have a will that's approved by the court, and that's part of the process, then the will dictates who will be in control, who can go to the bank and get control of that bank account, and who that person in charge has to give it to as an inheritance. The will dictate that. If you don't have a will, the law dictates who has priority to be the executor, or what the new term is known as personal representative, and who inherits it. So it's either going to be determined by your will or by the law who is in charge and who inherits, through the probate court process. But what determines if we're in probate is if you own something just in your name that has no beneficiary attached to it. So your IRA, as long as you have a beneficiary on there, won't go through probate. By contract, you stated with the IRA financial company who inherits it when you pass away. Life insurance, if you have a beneficiary, you've stated, here's where it goes when I die. Same with annuities. So those properties, those type of assets won't go through probate because they might be just in your name, but there's a beneficiary associated with it. Jointly owned property typically has survivorship, which means it goes to the other surviving joint owner. We don't go through the court process because it's not just in that person that dies name alone. So getting back to my bank account example, this person who passes away, if they have a will, that someone will submit that will to the court and be looking to be appointed the executor and looking for the court to say, yes, this is the last will of the person that died. Now the court won't know if this is the last will. They can read it to see if it has all the legal language and all the protocols that need to be in there, but they don't know certain other outside factors. They wouldn't know if this person had another will that they signed afterwards. They wouldn't know that. They also wouldn't know if it's actually that person's signature. It could be a fraudulent signature. Or maybe the person signed it but was incompetent. They had dementia, Alzheimer's, or some other cognitive issue where they weren't competent to sign a will. The court wouldn't know that. The court wouldn't know if there was someone that was somewhat forcing this person to sign that will. So that's why part of the court process is to prove that this is the last and valid will of the person. So we have to notify everyone that would have this information, which includes not only the people named in the will, but all the people that would have inherited if there was no will, because they may have the knowledge that there's something about that will that's not right. However, what the process usually does is it lets a disgruntled heir that was cut out of the will or is getting less than than what they believe they should be inheriting to go to court and object. And that just grinds this already lengthy process to a much slower process. Attorneys love it. They get paid more. That disgruntled heir may actually end up getting more by settling with the executor, the personal representative, but is that fair? Is that what the person that died really wanted? So it's really this process when someone dies to deal with only property in their name alone, and to determine if there's a will, that's the final will, and accept and approve that will, and appoint someone to take charge of the assets and make sure they're distributing it to the rightful heirs. It's not the end of the world, but I think most people, all things being equal, would prefer to avoid probate. They would like things to be as smooth, private, family-controlled, cost-effective, and easy as possible. And many times through the probate court process, it's the exact opposite. It ends up being public, court-controlled, expensive, and can take a very long time and frustrate the family. So, once again, not the end of the world, but I think most people would prefer to avoid it and make things as easy as possible and minimize someone coming out of the woodwork trying to get an inheritance that the person that died doesn't want them to get. So there's many ways of us to do that. Seeing a qualified attorney to walk you through that to avoid probate, if that's a concern of yours, is something I would encourage you to do. So I hope you found this information helpful. If you have any other questions or just not sure what to do next, feel free to reach out. Thank you.